Good morning and half a day, and welcome to the Guam Chamber of Commerce webinar series. My name is Catherine Castro, and I'm pleased to welcome you to today's session entitled Navigating the COVID-19 Minefield, Issues Employers Need to Consider. Our speakers today are Vincent Camacho, Principal, and Meredith Sayre of Counsel from the Camacho Calvo Law Group. Some housekeeping, as before we get started, all of our participants at today's webinar are on mute. You have an opportunity before the webinar started to send questions to Rebecca from the Guam Chamber of Commerce. If there are new questions as the presentation moves forward, you are requested to send these questions via the question feature, which is located at the right corner of your screen. And our chamber team will pass the messages to our speakers who will respond to them during the Q&A portion of the program. So let's get started. Vince and Meredith, welcome.
Thank you very much. Good morning. So I'm the lead. Are the slides up?
Yes.
Okay, and just as an aside, we decided to do slides so you wouldn't be sitting there staring at us all morning. We're doing our best on the technology. Think we've got it under control. But when we were setting up for this and we were looking at the list of attendees, it really struck me and made me feel kind of sad. I recognize so many of the attendees, and I'd like to be walking around table to table and saying hello and finding out, getting updated, finding out what's going on. And I think it's situations like this where we kind of stop and I just kind of have to pause and realize what a different situation we're in right now. I'm going to talk about the same old, same employment laws, except with a very, very definite twist. So we're in the midst of a global disease outbreak. A pandemic was declared by the World Health Organization, and the public officials use the pandemic assessment framework to determine the impact of a pandemic. Two main factors: clinical severity, how serious is the illness, and second, transmittability, how easy is it spread from person to person. The Center for Disease Control uses these factors to make their recommendations. And these are the same kind of severity factors that the agencies use, the federal agencies that govern labor and employment law issues when they're issuing their guidance and recommendations. So we have same old, same laws, but with a twist. So it's going to be very important for employers to continue to monitor the changes and the recommendations that the different agencies are going to be making. And knock on wood, at some point when we're back to our old normal. So how are you going to do the monitoring? Well, I'm going to put in a plug for the industry groups here. Employers Council is putting out great stuff. Guam Hotel Restaurant Association, look at their website. You'll find lots of useful stuff. SHRM Group, National End, our local chapter, great source of really easy to understand, really accessible information. And of course, Guam Chamber of Commerce, here we are. So monitor changes as they occur, rely on your agency groups, go on to some of the important websites. What's my favorite website other than the agency groups or the industry groups? OSHA has an extremely useful guidance on preparing workplaces for COVID-19. EEOC is putting out some good stuff too. And other agencies too, I'm sure, including the local Department of Public Health and Social Services is keeping us apprised. So stay informed. So I'm going to talk about, are we still on? What slide are we on? New slide. Sorry, this isn't the old way. So here we are, our Camacho Calvo Employment Group. Me, Vince, Jerry. Next slide, please. our agenda. So I'm going to be jumping around topic to topic, really giving you things to think about, not necessarily in-depth information, but some general recommendations, places to look for information, best practices, general information. And, you know, again, next slide, please. Our slides are more just to have something on the screen. So I'm going to start at workplace safety. And I think, you know, as I said earlier, the guidance on preparing workplaces for COVID-19, the OSHA publication, is really, really a useful starting place. You know, remember we've got that OSHA general duties clause. It obligates employers to prevent or minimize the risk to employees of death or serious physical harm in the workplace. Just at a minimum, employers should be following the prevention measures recommended by CDC and Guam Public Health. Keep track of the OSHA 30 log, and we're going to touch on that. The OSHA 300 log, I mean, we'll touch on that again in a minute. And keep track of public health announcements and respond accordingly. Don't do anything in a big hurry. Don't rush to open, don't rush to expand. Remember, you've got this duty to maintain a hazard-free workplace, and make sure when you do open up or do expand operations that you are following the OSHA guidelines. Just as to drive this in, if an employer doesn't follow these health and safety standards, if they violate the OSHA obligation to have a safe workplace, then the employer exposes themselves to a negligence claim. And those are lawsuits that might come from your employees. And so we're thinking, well, you know, if it's something that happens at the workplace, isn't that why we have workers' comp insurance? And that's true, but if you deviate grossly from the standards, I mean, if you're in a negligence issue, then workers' comp isn't going to protect you. So pay attention to safety guidance. It's really, really important. So a lot of this presentation, I pulled the material together based on the kinds of questions that I am getting from clients. So can we ask an employee to stay home? If we observe symptoms or what we think are symptoms, or we have some reason to believe the employee has been exposed, can I send them home? Well, in our old world that's familiar to this under the Americans with Disabilities Act, you know how cautious you need to be in anything that's involving health and so forth. But within our new brave new world, the answer is yes. If you think somebody is exhibiting signs of COVID-19, you can send them home. You can ask them to get medical attention. You can ask them to get tested. EEOC has specifically confirmed that it is permissible and it's not going to be considered an ADA disability related issue. Yikes. I mean, that kind of underscores how serious the situation is now. Can I do a temperature check? Well, I'm myself am not a big fan of doing this sort of thing. In the world that we knew, a temperature check of your employees would be considered a medical examination under the ADA, and it would definitely be a no-no. But under the new COVID EEOC guidelines, yeah, an employer can do a temperature check on their employees. I don't know really how useful that is, because sometimes somebody will be carrying or actually already have the virus and not have a temperature. As a practical matter, do you even want to do that? So if you have an employee that has tested positive I mean, whether they're coming to you and telling you, oh, my test came back positive, or you find this information out, send the employee home. That's the answer. Send them home. Before you send them home, interview them and ask them to identify people who they've worked in close proximity with, and that's within 6 feet. People they've worked with for a prolonged period of time, as little as 10 minutes. Let your other employees know that you have somebody within the workforce that has tested positive. Don't identify their name. You still need to be mindful of confidentiality laws, but you need to let your workforce know that we've had a positive case within the workforce. If you're in an office building or shared space, let management know so other tenants in the space can take appropriate action. Again, EEOC's confirmed, even if these are disability-related questions, if you have a reasonable belief based on objective evidence of a direct threat, you can ask the question, you can take the action, send them home. Should you report this information of the positive test to public health or CDC? EEOC says, yeah, you can. You can report that to CDC or public health. You don't have to, though. And honestly, that's the job of the healthcare provider. They're the one that's going to have the information on the positive test, not you, the employer. And I would tend to leave that up to the healthcare provider to do the reporting. Can you make your employees notify the company if they've been exposed? Yes, you can. And what do? Well, you evaluate the kind of information you have. How much likelihood is there that this exposure could result in an active case? But the long and the short of it is send them home. Ask them to stay home, self-quarantine for the 14-day period to see what's going to happen. Let other people in your workplace know there's a possibility, although it's not a positive test, and everybody should stay wary, stay careful, stay safe. So what if you have an employee that's fit and healthy and 100%, and they say, I'm not coming in because I am afraid. I'm not reporting to work even though you have work for me. So what do? So we're looking at the OSHA Act, and an employee is entitled to refuse work if they believe they are in imminent danger. And it's a pretty high standard. They're in imminent danger and can reasonably, there's a danger that exists that can reasonably be expected to cause death or serious health. And it's immediate. It's an immediate danger. Pretty high standard. I suppose you look at your workforce and do an assessment if you have that sort of a situation present. Knock on wood, you don't. But think about whether or not you can manage without this person. Just as an aside, also remember the National Labor Relations Act. Yeah, even if you're not a unionized entity, employees who engage in protected, concerted activity for mutual aid or protection are protected. So you've got a couple employees saying, yikes, I think it's unsafe, I don't want to work here, even though you do your own assessment and say, no, we're safe here, we're following the correct protocols. Employees are protected against discipline or discharge for engaging in protected, concerted activity. If you can do without these employees, consider letting them go home. That's your management call. What if I have an employee who, it's one of these, hard charging people, and they're not feeling well, they do have flu-like symptoms, and they say, no, I'm fine, I'm not going home, you know, ka-choo, cough, cough, I'm fine. Well, you've got to protect your whole workforce. Send them home. Err on the side of caution. Maybe it's simple flu, but they've got symptoms, the coughing, you know, maybe they have aches and pains, whatever. Send them home. What if they refuse to go home? Well, first take the gentle approach that you're looking out for the whole workplace and them individually. If they still refuse, explain to them that they're now trespassing on your property. You're going to call law enforcement if they won't leave, and you're going to consider terminating them for insubordination if they don't leave. Let's see. EEOC has confirmed that you can require a doctor's note stating the employee is fit for duty before permitting them to return to work. So that fit for duty note, that's what always before we put that in the context of getting information as part of an Americans with Disabilities Act issue, getting feedback from the doctor, or FMLA situation, check the box so you can require a fit for duty before you bring the person back in. But under this, under our current scenario, EEOC is generally allowing employers to require a fit for duty note from a medical professional. So now we'll just jump into the world of medical masks and respirators. What if you don't want your employee to wear a mask or a respirator? The employee wants to wear a mask or respirator, and you say, no, that's not necessary. That sets kind of puts a pall on the workplace. It's another OSHA issue. If there's a standard of when a respiratory should be allowed, if it's necessary to protect the health of the employee. And, you know, for the most part, I doubt if you'd be in operation right now if you needed your employees to wear masks or respirators. On the other hand, so you could say, no, it's not necessary. I've looked at the OSHA standards, it's not necessary. On the other hand, CDC has issued guidance recommending wearing a cloth face covering in public settings. So you weigh the two. If they want to wear a mask to work, under CDC, it's recommended you don't refuse. Under OSHA, you're going to look at the OSHA standard, you probably could refuse. But make a management decision that's going to make your life easier, which would probably be let them wear the mask. Can an employee refuse to wear the mask? So you are in a situation where you're telling your employees, I want you to wear a mask. So can the employee refuse to wear the mask? Well, do your analysis as though the employee has refused to do a task. I'm telling you to wear the mask, it's part of work, and you're refusing. You could probably force the employee to wear a mask, or not exactly force, but send the employee home if they refuse. For the employee can refuse if they are acting in good faith, if they genuinely believe that the mask is not necessary, we're looking at reasonable person and so forth. Masks don't necessarily protect, but they might. And again, I say might. Look at CDC guidance. Is it appropriate? Is it inappropriate? Err on the side of caution, and so forth. So we've had the question from employees, well, we do have work to do. A lot of the employees, the kids aren't in school, they don't have child care. Can we open a daycare? in our office? No. I mean, I suppose you could, but think of everything that has to go into that daycare, the licensing, sanitation, probably at a whole new level. It would be difficult. Think of it carefully if you are letting kids come into your workplace now. Sanitation issues, licensing issues. Think long and hard about that one. Okay, going back to OSHA and the OSHA 300 log. So that's the log that you use to record any workplace injuries. So do you need to record a COVID-19 case in the OSHA 300 log? Well, if you know with certainty that the worker got COVID at your workplace, then the answer is yes. Unless you're some sort of a healthcare provider, it's unlikely that it can be proven that the COVID came from your workplace. Healthcare provider, consider this, get some more detailed information. Maybe you will need to record it in your OSHA 300 log. For the most part, no, unless it did come from your workplace. Some employers are thinking of or have developed an infectious disease preparedness plan. You're not required to. It's probably a good idea, a good exercise. Think if you have a violence in the workplace policy, an active shooter sort of policy, it's sort of like that. It's the threat, the process. It might be a useful exercise. What do you do if you have an employee who has recently traveled in an affected area? And they may have been exposed to COVID-19. Well, I don't know. Think, some of us that have been in this business for a while remember the ADA direct threat cases, and one in particular that involved an employee who had hepatitis and worked at an oil refinery, and the toxic gases that this employee was being exposed to were a direct threat to his health. I mean, they were just killing the guy. And the guy said, "Oh, I need the money. I'm not going home. You can't send me." And that was ADA in the beginning. Then ADA was amended so that a direct threat could be decided by the employer. And it requires an assessment, objective evidence, and so forth. So carry that over to our pandemic, our worldwide pandemic situation. And EEOC says, yeah, we're right now in a situation where somebody traveling to some location where there is a lot of COVID and the likelihood of exposure constitutes a direct threat to that employee, a direct threat to the rest of the workplace. And so the long and the short of it is you can have that person sent for testing, sent for a medical exam. So I'm going to jump to a different topic here, and I'm just going to cover this briefly. Oh, is this on? Nope, we're still on the same slide. Leave it on this slide. I want to talk about premises liability just briefly. This isn't really an employment law issue, and what makes me want to talk about it is it's something that, oh boy, probably everybody in the audience in some shape or form is going to have to think of or be directly affected by. So premises liability, it's the duty that you have to third parties. So your tenants, your vendors, your contractors, your customers, the public, that you have to maintain hygiene and sanitation and safety and security within the premises. And the reason I I started thinking about this more is that I was recently in one of the malls. The mall has several businesses that are considered essential, and but for the most part, the mall is empty. So the landlord has stopped running the aircon. There's no fans. The building's otherwise shut up, and it's just dreadfully, deathly hot. The level of other services, like the cleaning and all that, lacking. It's been let go. Elevator not working, so on and so forth. So I bring this up because it's something that's happening, will happen more. In sympathizing with the landlord's like, I'm dying here. I don't, most of my tenants aren't paying lease rents right now. A lot of them are going to be leaving. I can't afford the security. I can't afford as much cleaning. I can't afford to run my my chillers. From the tenant and public perspective, though, it's like, hey, you have agreed to give me a building with certain standards and so forth, and you're killing me, and the public, you're killing me. So what's going to happen here? Well, the first step is you're going to look at your lease agreements, or this could even affect an employment contract. You're going to look at the leases or any other agreements and find out what the agreement is, what the level of care is supposed to be, who's supposed to pay for and provide for what level of services. And then that takes us to the next step. It's called force majeure. And it's a principle, a legal principle that excuses delay or performance as a defense. So what you need to do is look at the language in the contract or the lease agreement. Some contracts might specifically delineate pandemics and epidemics or outbreaks of disease is force majeure, so events that excuse performance. Others might be more general and refer to acts of God, events outside the control of the parties, and so forth. And some might be silent. Guam's business code also has a section that excuses performance or delay in performance when it's prevented or delayed by irresistible superhuman causes or by the acts of public enemies of the US. I have a feeling we're going to see a lot of litigation based on premises liability. It would be probably a very good idea to have candid conversations with your landlord or your tenants or your suppliers and so forth, your business partners right now, and try to get everybody working in the same direction. Nobody's happy. Nobody's going to be a winner in this whole thing. Okay, now, new slide, I think. And I want to talk for just a minute. I guess it's a new slide. I want to talk for a minute about remote work. So a lot of companies are trying to allow their employees to work remotely. Should you do this? It is entirely up to you. It's entirely up to your organization and its circumstances. If this means introducing a new system into the way you do business, haven't had time to test it, you don't really know if it's going to work, if it's going to be worth it, maybe you don't want to do this. If you have jobs that could be done at home, then maybe this is the right thing for you to do. Consider, if you are thinking about remote work, telework, if you've got a job that the employee doesn't have to be at the workplace, then maybe it's a good choice. Consider whether this employee is exempt or non-exempt. Your non-exempt people, these are your hourly people. Is it going to be possible to manage these people working from home? Is it going to be possible to keep track of what they're doing, how much they're doing? Are there security protocols if they're using company equipment or they're logging into company sites? Are there any security protocols you need to worry about? It's going to be up to you. Your non-exempt people, your white collar people, probably easier to manage remotely. They're working on a salary basis, and they probably have, I want to say, the kind of job that already requires a lot more discipline and independent discretion. So if you decide to allow remote work, suggest you come up with some kind of a policy, a specific work schedule, reconfirm the responsibilities, the performance expectations, the rules, the projects that are going to be worked on, time frame for these projects to be completed. Document this, have your employees sign off on it, that they understand this. And monitor how it's working. Is it going to work? Is it going to be a kind of privilege that gets abused? Is it going to be something that the employee, with the kids running around or the lack of a good workspace, that it's just not going to work? It's just going to depend. One other thing, consider whether there are any workers' compensation implications. Having your employee working remotely and so forth. Let's spend a short minute on HIPAA issues. So HIPAA, privacy issues, something that we're familiar with. You know that you treat all medical information as confidential and provide, the necessary protections in connection with your group health plan. You know that all medical information, it has to be kept private, confidential, wherever it's coming from, under FMLA, under ADA, private need to know. But what if during this whole COVID thing, a government official or health agency asks you for information about your employee? What are you gonna do? Well, first of all, HIPAA, except for healthcare providers, applies only to covered entities. A covered entity would be a healthcare provider, or and so forth. So in many respects, your workplace isn't going to be considered a covered entity. But nonetheless, if you're asked for this kind of information by a public, like public health, you can provide it. Just be careful that you're dealing with somebody who is who they say they are, that they have the need to obtain this kind of information, but you can provide health-related type information to a public official. And now we're going to do an even briefer coverage of benefits and group health plan administrations. So things are changing. Some of your employees are furloughed. Some of them are working greatly reduced hours. Consider whether this changes whether they're eligible for your group health plans and other insured benefits. Take a look at eligibility requirements. The question would be, my employee is no longer working. Are they still entitled to the group health plan coverage? What if they're unable to pay their share of the premiums right now? And my answer to this is go to your plan providers. These are very serious questions. This is a heavily regulated industry. These are heavily regulated benefits. Go to your plan providers and sit down with them with your questions. Okay, let's take a jump now into wage and hour issues. Whenever there is a significant change in the way we do business, wage and hour issues always need to be considered. And I would hate to see somebody get into a wage and hour claim because they're trying to do the right thing, but they just don't do it correctly. So pretty much all of the same Fair Labor Standards Act issues apply, but you need to be thoughtful. Do you have to pay somebody because they're not working? No, you don't have to pay somebody if they're not working. Your hourly employees, you continue to pay them based on how many hours they're working at their hourly rate. You continue to document it just like you always have, time in, time out, and so forth. And this is one of the challenges when we were talking about remote working. You know, yikes, did this person really spend 8 hours producing this work product? That's going to be one of the challenges of remote working. But for wage and hour issues, what you decide to do, if you can't control their time, don't dock it, just discontinue the remote working. Don't dock it unless it would be better to pay them for that work week that things didn't work out so well than taking it upon yourself to decide what they should have been billing or should have been recording. For your white collar people, for your exempt employees, could be a little more difficult. So remember, to be salary exempt or to be payroll exempt, you're looking at a salary basis test, and on Guam it's still $4.55 a work week, and you're looking at a duties test. Often in a down economy, when you've got a lot of your hourly people are laid off, you find that your managers are picking up the slack, and a lot of the work that they're doing may not be considered within their exemption under the duties test. They might be doing a lot of hourly work. And if that's the case, the employee is being converted into an hourly employee. So now you've got somebody who you're paying on a salary basis. Really, they're an hourly employee based on the duties test. You need to make an adjustment there. What do? Pay them on an hourly basis and have them record all of their time worked, including overtime, time and a half. It's possible to convert, it's easy to convert a salary-based employee, an exempt employee, to hourly. But the question comes in also, can I reduce wages? Can I reduce my hourly employee wages? Can I reduce my exempt employees' salaries? Well, the answer is you can. Probably for your hourly people, it's better just to reduce hours. They're performing the same kind of work, just not so much of it. For your exempt employees, there's a Department of Labor formula. If you're going to reduce their salary, remember it can't go below the $4.55. It has to be done prospectively in the future. You've got to have a factual basis for making this change. Department of Labor really doesn't like it when an employer shifts employees back and forth. Now you're exempt, now you're non-exempt. Have a fact-based basis for why you're making this change. It's something that's going to be done for the long term, for the long haul. You can't go back and forth. We're busy this week. This week you're exempt. This week we're not busy. Now you're hourly. You can't do that. It has to be for a sustained period of time. You need to document all this. So you can't dip below the salary minimum, $4.55 on Guam. You can't go back and forth. It has to be prospective, and it has to be for a long, I'm not week to week, for months at least, if you decide to make this change. These are the kinds of things like reducing salaries, reclassifying people. No employer wants to do that, but sometimes you have to do that. When we're talking wage issues, you think of, when people say, well, what's the most important thing a business does? Or what's the most important thing about doing business? And, you want to say, oh, making a profit, making money. And that's not really the case. The most important thing is staying in business, staying alive. So sometimes you have to make these drastic cuts. Do it thoughtfully, though, do it correctly. The Department of Labor publishes really good fact sheets, very user-friendly, easy to understand. So if you're thinking of these changes, go onto their website, look for some fact sheets that apply to your situation. Oh, right. Question, does family medical leave apply to this situation, our COVID situation? Well, it still applies. It applies if it's still the same qualifying event. FMLA would apply. Under FMLA, employees are generally not entitled to take the leave just because they want to stay home. It's got to be the same FMLA qualifying reasons. Does COVID-19 implicate the ADA? We've kind of talked about that. Generally, no, because remember, ADA is a major life activity, such as, breathing, walking, talking, thinking. And COVID is considered a transitory condition. You're supposed to get well. So automatically, ADA isn't automatically implicated. If you regard somebody as disabled because of the COVID, you're in the regarded as category, and so forth. ADA, we talked about this under other standards, but can you send somebody home? Yeah, you can send somebody home in this scenario. ADA, EEOC is fine with that. ADA, the kinds of questions that before we would not ask about medical conditions and symptoms. In our current pandemic situation, you can ask those questions. You can go into the direct threat area and so forth. And, remember, knock on wood, we won't always be in this situation, and we'll go back to the more conservative interpretation of ADA, knock on wood, sometime soon. So let's spend a few minutes on general discrimination and harassment type issues. So what kind of EEO, equal employment opportunity concerns, do you have related to COVID-19? Well, you know that you're supposed to have a workplace that's free from discrimination and harassment. So prohibit gossiping, gossiping about somebody's health, gossiping about somebody's national origin or ethnicity. I don't think we see that here. Oh my gosh, they're Asian, what if? Well, you know what? Almost everybody here has some kind of ties to Asia. But monitor these kind of things. The same kind of thoughtful management you already do, and your managers, if they see an issue like that, they report it and they deal with it. HR deals with it accordingly. Now, another hard issue, and this has EEO issues. This has possibly discrimination and harassment issues and ADA issues. But the overlay here again is going to be, hey, but we're in a worldwide pandemic situation, so the rules are different. So what if you start bringing back employees, or what if you're still laying off employees and you think to yourself, I am worried about the pregnant lady. I am worried about the old person. I am worried about some of my employees that I think have compromised immune systems. I'm going to lay them off first, or I'm going to delay the recall with these kinds of employees. Well, in the world that we knew, and I hope we know again pretty soon, you can't factor that in. You can't make these general assumptions. Oh, they're older. I'm not going to bring them back. Oh, I know that person had some health issues in the past. I'm not bringing them back. That would be a definite ADA problem. But now our assumptions are different. If you think that you have a credible basis for your decision and going back to an ADA direct threat sort of scenario, you're probably okay to delay the callback of somebody with a compromised immune system, somebody that's just older or somebody that's pregnant. Think longer and harder about that, whether you've got an ADA direct threat sort of scenario. So when you're making these kinds of decisions, you've got to have legitimate, non-discriminatory reasons, like the compromised immune system. Be transparent, talk to your employees, have a discussion with your employee and that you're making this decision about. Have a rational basis for any of your decisions for bringing them back to work. And be mindful of OSHA standards and CDC standards when you're making these decisions. So the answer is, yep, maybe you can factor in some of these things when you're bringing people back. If you can fit it into a direct threat kind of situation, but be very thoughtful about this. All right, switching subjects again, and we're going to cover this one just really briefly to, what slide are we on? I want to just mention WARN Act. Is that on the next slide? Next slide, please. Okay, WARN Act. So WARN Act is the Federal Worker Adjustment and Retraining Notification Act. And the purpose of WARN Act is it's a notice requirement, and it's given to the government and to covered employees, employers with 100 or more full-time employees. It's the notice that's given to the government or the employees of a pending plant closing or mass layoff. WARN Act has lots of details, but if you have more than 100 employees, if you are anticipating a layoff that's going to affect, what's the number? If you have more than 100 employees and it's going to be a mass layoff, you might be required to give this notice. Generally, this is a notice that's given 60 days in advance. 50 employees, that's the number. With 50 or more employees are going to be subject to the layoff. You might consider whether you're required, or you should consider whether you're required to give a WARN Act notice. 60 days prior notice, today we're laying off 20 people and we hope that's it. A week passes, we're gonna let go of 5 more people. A week passes. So you're using your very best faith efforts and guesstimates on whether or not you're gonna hit the number. If you think you're gonna hit the number, 50 or more, do the notice. If you find yourself having to lay off more people, do the notice, even if it's not within the 60-day prior, even if you've missed that time frame. Good faith and your best efforts to do this notice. The notice is given, of course, to your employees. It's given to the governor, and then it's also given to the government. So who's the government? I don't know, Vince, who would you say? I would send it to labor. I would even consider sending it to other agencies too. So WARN Act, knock on wood, hope you don't have to do that notice, but keep that in mind. The question has been, well, it's so hard. We don't know. Do you think it's going to be enforced? It's a U.S. labor issue, U.S. Department of Labor. Yeah, it's going to be enforced. So don't skip over it. Don't ignore it. How about USERA, military leave issues? Nothing's changed. If somebody gets called up, you got to let them go. But what if I'm doing a furlough or a permanent layoff? What about my service member employees? You're going to treat them the same way as anybody else. They're going to be subject to, vulnerable to furlough or layoff. Be sure you've got a good plan in place so you can you have objective sort of information about why a service member was laid off, and that's your defense under USERA. Okay, quick treatment of workers' comp. So what if an employee wants to make a claim on your workers' comp insurance policy because they think they contracted coronavirus while they're at work? Is this a compensable claim? Well, it's going to depend. If you are a healthcare provider, maybe it is. If it is just a different, an otherwise kind of business, it's going to be fact related. Remember, workers' comp, it's a no-fault system, meaning the employee claiming work injury doesn't need to prove negligence on the part of the employer. The employee only needs to prove that the injury occurred at work and was proximately caused by employment. They make the claim, they're going to have to prove the claim. It's going to be difficult. You as the employer, you're just in good faith, you're going to process the claims as they are made and do what you would ordinarily do if an employee comes to you and says, I think I've been injured at the workplace. Okay, we also have plans for business slowdowns. I have a feeling you guys are unfortunately already pros at this. You know, things that employers are doing now, reducing hours, requiring their employees to take vacation or PTO, rotating work schedules, temporary furloughs, temporary layoffs, permanent layoffs, and unfortunately also closing down the business. Check with your insurance providers. See if there's any insurance coverage, business interruption, anything that will help you. Think of liability claims, workers' comp claims, and so forth. It's a hard exercise. So my final suggestions before Vince takes over: document your decisions. I mean, it's always, we say document, document, document. Well, document your decisions. When you make a decision, be really mindful of the purpose of the decision and the kind of documentation that you include to show that your decision was based on legitimate business reasons. They were consistent with public health protocols. Keep a copy of the government recommendations in place at the time you made that decision, because remember, we're seeing change all the time. So at the time you made that decision, this is what public health was telling you. This is what EEOC was telling you. Do a memo to file on your rationale. This kind of exercise helps you think clearly when you're making the decision. And it's also part of your defense if something comes back to bite you. Keep all communications to and from your employees, especially regarding telecommuting, you know, in case later there's a wage and hour issue. keep conversations, written oral notes regarding voluntary quarantines, paid and unpaid leaves, and other benefits that have been triggered. And always, 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 this kind of information, and especially anything that overlaps into medical, health-related, secure, separate file cabinet, need to know access only. So those are my comments. And other than that, you know, Guam is a survivor community. It's probably the best place to be in this kind of a pandemic situation right now, and we all just need to hang in there. Vince, turning it over to you.
Okay. Next slide, please. Okay, the famous FFCRA and the CARES Act provisions. I'm going to skip through a lot of these because I'm sure all of you have read the chart that the Chamber has provided to most of you regarding both of these, but there are still some clarifications that I think should be made for the employers. And I'm going to just refer to them as either the paid sick leave or the extended FMLA. As you all know, the effective date for both of those is from April 1st, 2020 through December 31st of this year. None of the benefits extend beyond the December 31st, 2020 date. Again, the exclusions, it excludes any employees who are healthcare providers, and the Department of Labor has exhaustively defined what a healthcare provider is, and that's also provided on the chart, together with what an emergency responder is. And it pretty much covers anyone tied closely to a healthcare facility or even an educational facility that addresses healthcare issues. Covered employer is any private employer who employs less than 500 employees. And for this, it includes public employers, or the government of Guam employees. How you count employees for the basis of determination of the number of employees is also described in there. You would count part-time employees for the purposes in this case as a full-time employee. A lot of questions we've been fielding with regard to the small business exemption for those employers who have less than 50 employees. Keep in mind that the small business exemption only applies to qualifying reason number 5 under the paid sick leave and under the extended FMLA. So that means it's only for reasons to take care of a son or a daughter. And again, those are defined in the statute as well as in the Department of Labor guidance. And you must document that a determination was made based on the above criteria. I'm not going to get into the qualifying reasons, but as you guys know, there are 6 qualifying reasons for paid sick leave. And for extended family medical leave, it is strictly to take care of a son or daughter whose school or place of care has been closed and whose child care provider is unavailable for reasons to COVID-19. One issue that has recently popped up, and we're still looking at the guidance from Department of Labor, is school is set to be generally in the real world situation or in the prior world situation. School is set to be out relatively soon, within the month of May or early June. And so the question has popped up, does extended FMLA extend to the summer months? As guidance, we would recommend that you would extend it until the time the 10 weeks is allowed under extended FMLA. But at this point, the Department of Labor is still reviewing that issue. Some have taken the position that because school is set to let out, let's just say May 15 is the date, then the employers are able to treat that as a regular summer type function. But again, we're not in the real world at this point in time. We're in an alternate state. So, just keep that in mind. And now is the time to start thinking about how you would enforce or apply the provisions of the FFCRA with regard to that. The amount of leave under the paid sick leave is 80 hours. For the extended FMLA, it's 12 weeks, and this is concurrent with current FMLA, so it's not an additional 12 weeks. The only difference is that for FMLA, extended FMLA reasons, it is paid. Intermittent leave, this is a question we've received a lot, again, from our clients. Intermittent leave is not permitted for qualifying reasons 1 through 4 and 6. So what does that mean? It's only allowed if you're going to take care of a son or daughter under both the paid sick leave and extended FMLA leave. In the chart that we provided the chamber and to all of you, I would recommend that you take a look at page 4, which is relative to taking the paid sick leave and extended FMLA provisions concurrently, because there are a lot of our clients that have issues related to. So if you recall, the extended FMLA allows for 12 weeks. The first 2, which are unpaid, and the remaining 10 paid. So some of the issues are, can they use extended paid leave to cover for the first 2 weeks? The answer is yes. And some of you may be aware that the coverage for the salary is up to a certain limit. So for taking care of a son or daughter, it's 2/3 of the regular rate. Some of the questions we've received and provided guidance for is, if an employee wants to use paid time off to cover the 1/3, can they do that? And the guidance provides yes. But as some of our clients will know, some of you may be online, the payroll, your payroll system has to be really tweaked in order to help provide the record keeping required in order for you to take the tax credit by providing these 2 benefits. I'm sure all of you by now have provided your employer notice to all your employees. Another question we get is, what notice is an employee required to provide? And we provide that again in the chart as to what you can provide. The key takeaway from here is that you don't have to require the notice prior to them taking the leave, but you should be able to request for the documents at some reasonable time, either during the leave or upon return from the leave. Just keep in mind, as we are in a lockdown, there may be difficult for some of your employees to obtain some of the information in order to provide you as the proper notice for the leave. Under the FFCRA, you must maintain your group health benefits during the entire leave. So while the employees are on leave, they are required to pay for their premiums. And Meredith talked earlier about what happens if you don't, or the employee is unable to continue making payment. Talk again to your plan provider and see what you can do. Some of our employer clients have taken the reins and just said, we'll pay for your employer health insurance during a certain amount of time for the first 30 days. Return to work, again, you are able to request for certification for someone who has taken paid leave under qualifying reasons 1 through 4. Record keeping, again, keep in mind that the main reason behind the FFCRA was to keep people employed. And so as an incentive, the government has provided that employers may take tax credits for the payroll tax for providing that leave. And so that's going to require additional record keeping, which I'm hoping, and from what I understand, a lot of the payroll providers, at least on Guam, have already instituted their systems in order to address that issue. Again, the discrimination rules that Meredith talked about earlier continue to apply, and none of the FFCRA doesn't necessarily affect your current employment policies. So it's not intended to take away from any of those issues, but rather just to add an addition to that. So that's my spiel on FFCRA extended leave. Can we go to the next slide, please? Okay, and now one thing that I could say that's sort of a good thing is that for the last month and a half, you guys have been practicing many of these things in order to help bring your businesses back into business and to bring your employees back. But for the reasons Meredith has described previously, now's the time to start revising your policies. There are 5 sort of litigation traps that employment lawyers are looking at right now that are potential once we start bringing people back to work. And Meredith touched on them. One, of course, is the Fair Labor Standards Act with regard to wage claims. You know, some of you have laid off, some of you have furloughed, some of you have cut hours, and keeping track of all those wages is a monumental task. So, you know, make sure that whatever systems you have in place, you're tracking them properly, because that's the first. You don't want to have a wage and hour claim a month after you bring everybody back to work. The new leave provisions under FFCRA and the CARES Act may also provide a potential for litigation there, because of who you allow time off to, who you don't allow time off to. So, you know, make sure you follow those policies carefully. Meredith also talked about safety in the workplace. You all heard on the news about food processing facilities, retailers, and how a lot of employees have fallen ill during the pandemic and perhaps in the workplace. Right now, a lot of the guidance is relying on workers' compensation, but as Meredith did say, it's going to take proof to determine whether someone contracted COVID in the actual workplace and whether workers' compensation insurance carriers are going to put into place certain checklists or, you know, to determine the actual facts. Also for layoffs, furloughs, terminations, there's potential for WARN Act violations. There's potential for failing to provide a sufficient notice and laying off arbitrarily in a discriminatory fashion. The other thing is, as Meredith talked extensively on, is the ADA requirements. And so when you're going to transition people back to work, she did talk about some may be reluctant to return to work, and that may have ADA implications. So take a look at your current policies now, and now's the time to tweak it before anything gets lifted with regard to having to bring people back to work. You know, most of us are in a situation where we hire on an as needed basis. So if we need a secretary, we need a cashier, we hire them intermittently. going back to work, we're going to hire in bulk. And then Meredith talked about this again in the discriminatory policies on bringing people back to work. Make sure you do it in a process where discrimination is not, or minimizes the discriminatory function. Again, forcing people back to work too soon, you may need to change your policy on saying everyone comes back to work on Monday, but take a look, talk to your employees, get their feedback, because this is going to be important to help mitigate risk and individuals who are still fearful of potentially contracting COVID. The next one is implement workplace safety measures. We're not in normal times, and we're not going to be normal times anymore with regard to the workplace. Meredith talked about, so of course there's social distancing standards, there's physical barriers that are going to need to be put in place in the workplace. You need to, what they call, de-densify your workplace. So a lot of companies now are going back from the open space and making sure there's sufficient space. So this may require a lot of employers at this point in time to reconfigure your workplace. And this, of course, will cost money, will take time. And how do you fit 20 people in a room that now you can only fit 5 or 10? What do you do? These are a lot of issues that have potential pitfalls if you don't take those things into consideration. I mean, an employee may not want to come back to work because they feel that they're sitting too close to a coworker, and they may not want to do that. So again, take into account your workplace safety measures, knowing that you're going to have a different workplace environment than you did before. Some of the things, a lot of recommendations coming in is stagger your work hours. So you have team A comes in from 8 to 12, team B comes in from 1 to 5, or alternating days. Team A works Monday, Wednesday, Friday from home. Team B works in the office, and then the alternate days shift. So, those are types of changes that may be on the horizon, considering what's going on now. Again, Meredith went through health screening, implement proper health screening protocols, taking into account that information still remains confidential. There are pieces of information that may be required depending upon your industry and your type of work that you do that may be required to be identified and reported to government officials, but nonetheless, most of that is confidential. And finally, we need to take a look at creating flexible work arrangements. Again, it's no more 8 to 5, all in one workplace for everybody at the same time. These are things that may have to change. And so these are the considerations you should take into account before everyone starts coming back to work real soon. I don't have anything else. I think Meredith now will take questions.
Vincent, I will take questions.
Okay, just before we go into that, I just wanted to let everybody know that we only have 15 more minutes left on the webinar. I wanted to also let everybody know that if you look at the handout section on the left side of your, the right side of your screen, we have uploaded the FFCRA chart that Vince was referring to. So if you would like to take a look at that, and if you haven't had a chance to, you're welcome to. So all you need to do is click on it, and it's available for download. We've also made available the workplace readiness essentials that we've kind of put together, and that's also available for download. So going back to the questions, so there's a list of questions that members have put up, and you're welcome to scroll through them and decide which ones you're going to answer. I'm so sorry, we only have 15 more minutes left.
Okay. First question, if employee is sent home to self-quarantine due to possible exposure, do you need to pay them? Fair Labor Standards Act, no, you don't need to pay them. They're not performing any work. If they are performing any work, teleworking, answer's different. Careful of your exempt managers. They're not performing any work. You don't need to pay them, but there's always the tendency to call them up and say, hey, what do you think of this account? Do you think we should blah, blah, blah? Huh? They've worked for the whole work week there. So we're looking at Guam and federal law. Does any federal aid apply to this?
Very good question. So if an employee is sent home to self-quarantine due to possible exposure, again, yes, the federal aid would be under FFCRA, and that would be the paid sick leave provision for up to 80 hours. The caveat there is they have to have notice that they've been exposed, and so it's specific to that employee.
Okay. Rolling down, whoops. Okay. Sorry about this. We're okay. Yeah. Does the employee legally required? Is the employee legally required to notify the employer if they test positive? I did not see it in any of the material I read. You would certainly hope so, but what do you think, Vince? I mean, I can think of other like non-employment law type things and getting into, oh.
I don't think the employee is legally required to notify their employer. However, in most cases, the employee would probably either want to be on leave or tell the employer that they're not able to come to work, because if they don't tell the employer they're not able to come to work, the employer might terminate them. And so, even the employer asks, why aren't you? Under the guidance from the EEOC, an employer can ask an employee why you are not coming to work, which will not violate any legal requirements with regard to medical information. So you can call the employee and say, why aren't you coming to work? And if they still don't tell you, then all remedies are available to the employer, but I don't see any guidance where an employee is required to tell the employer.
No affirmative duty, but you've got relaxed ADA standards, like Vince said, and you can do some inquiry, which you couldn't have done before. They're sick and they're afraid to come to work. We covered that. Maybe they're afraid of their boss. No, I'm just joking because Vince is my boss. I'm not afraid of him. Can we refuse entry for an employee into our workplace if we have evidence they're knowingly interacting with people not staying at home and so on and so forth? You're going to weigh the risk, and I think in our current climate, I would say, yeah, you can. You're not on board here with all these measures we're supposed to follow. Can they get paid when they're at home? So Vince, that's kind of
Does
your.
someone who gets sent home because they're sick also get paid while they're at home? Well, that depends on your employee policies with regard to paid leave. But if they're going to seek the benefit of the FFCRA, then they have to meet the requirements to do so.
That's the old lawyer talk. It depends. Okay, afraid to return to work. I think we covered that. Retro back. Yeah, it can be retro back. Yeah. Sorry.
If the employee took company paid leave in April and is eligible for EPSLA and EFMLA, can the employee's company pay? Yes, as long as it happens after April 1st.
Yeah, after April 1st. Yeah, what if they simply, sorry, we're reading this instead of hearing somebody asking this question. What if they simply choose not to return to work? Can they be terminated? Yes. Receiving higher pay increases, bonuses, as long as you're within the confines of Fair Labor Standards Act and any contracts you have with employees, yeah, you can do that. The childcare one.
Yes, if an employee requests EPS paid sick leave and extended FMLA due to child care school closure, I think I addressed that, then takes leave, then schools are reopened.
Sorry, having a little clicking issue here.
Does their leave continue? No. Again, you can always stop the leave if you look at the chart, it will tell you what is required. And so the employee has to show that there is no other way to take care of the son or daughter. So their leave can cease if the schools are reopened and they're back to school.
Do people who are not called back to work continue to receive pay? Well, ordinarily, no. If you're not working, you don't get paid. Consider, and one thing I kind of didn't mention is if you're in a unionized company, you might have collective bargaining act issues you need to deal with. But they're not called back. Under Fair Labor Standards Act, they're not working, they're not entitled to pay. Yikes. We have an employee who went off island under FMLA for medical reasons. FMLA was exhausted on 3/14, but employee requested additional leave without pay for final treatment. We were just informed by the spouse that the employee is in the hospital and has contacted COVID-19. The spouse is asking for a furlough letter that was issued to all employees on 3/22. Is employee entitled to FFCRA or PUA, etc.? Since employee is still off island, if yes, what documents are required from off island?
I can touch on the extended FMLA. Once it's exhausted, then they can request for leave without pay, but that's on the employer policy side and not necessarily under FFCRA. Again, under FFCRA, the limit is 12 weeks within the 12-month period. Now, the 12-month period is depending upon what you as the employer has determined what your 12-month period is. Every employer has a different 12-month period to go back to. There is guidance in the Department of Labor that you can go from one 12-month period to another 12-month period to continue the extended FMLA. So if your 12-month period ended in July and they've already exhausted it and we're back into July of this year, which restarts their new FMLA period, you can straddle two FMLA 12-month periods.
Next question. If you furlough an employee, does the sick leave pay apply? Look at your policy. Are we just talking a general?
For FFCRA, no, it does not.
For FFCRA, no, but non-FFRCA responses, look at your policies. They're furloughed, but they're still your employees. So I would suspect your regular policies would still apply. Insurance, when employer pays half and employee does not pay remaining, what happens? Well, we covered that. I would talk to your plan provider and see if arrangements can be made. Maybe the employer, many employers are picking it up. If it happens that they're not entitled to, or they lose the insurance, remember to give them their COBRA notice. If we feel that a staff is abusing childcare eligibility, what can we do to confirm?
Again, in the FFCRA chart, there's specific requirements that an employee needs to provide. One example that we've been had to answer is if you have two parents and one parent, or you don't know if both parents are eligible or able to take care. So if both parents are able to take care of the child or children, then you can require that employee to come to work if the other parent is available. If not, then in their notice to you as their employee notice, they need to explain why the other parent is not available.
And this question is a good example of why you want to always square up the corners. So you have one person who you think's abusing, you ask them for the documentation, you're being pretty slack with everybody. The person that you're suddenly asking, they're going to say, oh, is it because I'm, XYZ, my national origin is this, you favor them, you don't ask them, so on and so forth. Ask everybody for the documentation. That's yours, Vince.
For qualifying reason number 3, for example, does the certification note from the healthcare provider have to state that the recommended quarantine isolation is COVID-19 related? Yes. For reasons 1 through 3, they must be COVID-19 related.
OSHA states that employees are entitled to refuse work if they feel they're in imminent danger. Does this apply if the employee's reasons are based on the potential for them to infect someone in their household who might be more susceptible? It is going to be really fact specific. It's that imminent danger standard in OSHA. It's a pretty high standard. I would, if you're an employer managing, I would think about, can we accommodate this person and not even go down the OSHA? Probably the OSHA question is going to be no, you don't have to, but manage like a human being when you get these kinds of issues. Whoops, I keep scrolling down too far. So did you cover that?
What government assistance can an employee get if the company, the only other thing right now is the unemployment insurance.
Does Meredith always win best dressed at work versus Vince? That's from Nate. No, Nate. Especially during these COVID times, I'm looking pretty, I'm not even going to go into who gets to get a haircut and who doesn't. We'll keep going. Don't know, not sure what that means. If employer retains the employee under PPP loan from SBA for the 2.5-month period, but the business does not recover enough to retain them past the 2-month period and furloughs the employee, can the employee then apply and qualify for the unemployment benefits? Man.
I think the way this works is that if you go out of business and there's no opportunity for the employee to come back to work, they may be able to apply for unemployment insurance at that point, but it's have to be when the business closes.
Yeah, and it's, we have a pretty good idea of what we think is going to happen, but we don't know for sure. There's another PPP one.
because the staff are going to get full pay under PPP, can we have staff come to work to do some general cleaning? Yes. What if they don't want to come to work because it's free money? We can force, it's not free money. The whole purpose behind the PPP is to keep employees employed. And so you will still have the opportunity, if the employee refuses to come to work, you still have the option to terminate at that time or put them on leave without pay.
You know, really, you're changing their job description. If they don't want that job to come in and do something else, then they can quit or be terminated. Yeah, this is the issue if if the employee doesn't want to come to work. It's an OSHA. The answer is it's an OSHA issue, and it's the imminent danger, very, very high threshold. So probably you could terminate if they refuse to come in. It's going to be fact specific. If the employer's evaluation based on credible, legitimate, rational basis is an employee cannot go back to work yet due to direct threat on his or her condition, and the employee still insists on reporting back to work, what can the employer do? The employer can tell the employee they cannot come back. And this gets back into ADA direct threat as we knew it. But in this pandemic situation, you can tell them you cannot come back to work based on your, you know, and you have to feel like you can defend what your decision is and so forth. I see Catherine there. Is time up?
You guys did fantastic. We went through all of the questions, so speed answering, and so thank you so much. I'd want to thank you for your great presentation today. I think that we have good feedback from the participants, and so we want to thank you. We will try our best this is to all the participants to, we are recording this, so we are going to try our best to have this put up online, and when it is, we will let you know so that you can refer back to it. And then one last thing, if you go to your handouts again, there is a GVB invite for another webinar today at 1 o'clock. And for all of you who have questions for Dave De La Sola and the Department of Labor, this might be a good time for you to participate. And so that is on Facebook Live at 1 o'clock. And if you go to GVB's Facebook page, you should be able to avail of that particular webinar. So again, thank you so much to Vince and to Meredith. We truly appreciate you. And we look forward to seeing everybody again at our next webinar. So have a happy Friday, everybody. We'll see you again soon. Bye now.
Thank you for inviting us.